views matter.
रेडियो जिंदगी 1170 AM पे वेलकम लिसनर्स, मैं हूं आपके साथ में ईरा एंड वेलकम टू शाह पीराली लॉ शो. यस, वी हैव वंस अगेन शाह पीराली ऑन एयर विद अस. He is the founder, president and managing attorney at the Shah Peerally Law Group, which is right here in Newark. He is a member of the American Immigration Lawyers Association as well as the State Bar of California. He is a passionate advocate of human rights, civil rights, social action and social services, and he has a strong interest in and knowledge of the political legal system in the U.S. He formed his law group to work on the causes he feels most ardently about. The law group focuses on the immigration laws with an emphasis on employment-based immigration and helps clients all over the U.S. Listeners, his office is in Newark, San Francisco, Washington, D.C., so you can make an appointment to whichever place works for you, whichever is closest for you. So definitely get in touch with him, pick up the phone and give them a call on 510-742-5887. That's 510-742-5887. उनकी वेबसाइट है peerallylaw.com. That's PEERALLYLAW, peerallylaw.com. और अगर आपको अभी शो के दौरान कोई सवाल पूछना है, इमिग्रेशन के बारे में कोई क्वेश्चन है आपका खास करके, आप जरूर फोन कीजिए 510-657-1170 पर. दैट्स 510-657-1170. ये है स्टूडियो का नंबर. 11 बजे तक शाह पीराली हमारे साथ जुड़े हैं और थोड़ी देर में वी विल ऑल्सो बी जॉइंड बाय शरीफ, अटॉर्नी शरीफ, हु विल बी ऑल्सो टॉकिंग टू अस अबाउट व्हाट्स गोइंग ऑन एंड गिविंग अस द अपडेट्स. सो रिमेंबर, आप उन्हें डायरेक्टली फोन कर सकते हैं. अदरवाइज द स्टूडियो लाइन्स आर ऑलवेज ओपन फॉर एनी क्वेश्चंस दैट यू मे हैव, स्पेशली अबाउट इमिग्रेशन, ऑल्सो फैमिली लॉज. तो चलिए, विदाउट एनी फर्दर अडू, हाय शाह, गुड मॉर्निंग.
Good morning, how are you? I hope everybody is doing well at Radio Zindagi. And I know it's kind of hard to ask people if they're doing well right now, but I hope at least people are hanging there and a lot of things happening, of course. And before I start, Ira, the usual, anything I'm going to tell people today is my opinion and Sharif's opinion also. And you should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And I wanted to let people know that we're going to have Sharif, like you said, at a later stage. Hopefully we'll talk about different issues from the visa bulletin and the two cases he won yesterday in a row. So I'm very proud of his team and our team here for making this happen, and congratulations to the client. So today we're going to talk about different issues, and of course people are able to call on 510-657-1170 if they want to call on air. I know now more and more people are a little bit kind of worried about calling on air. They're either sending a message or also asking questions at a later stage, so they can also call our office for private consultations, 510-742-5887. So today we are going to discuss about, of course, all the issues, but there are so many things happening and the confusion is getting worse and worse, but at the same time good things are happening. We are expecting hopefully a visa bulletin that will be cross our fingers, or inshallah, like we say, if God willing, we can actually make this happen. It does happen that we will see a good movement on the EB categories. As you know, a lot of people have been waiting forever when it comes to those employment-based categories. So we are expecting a good move on EB1 and also a good move on EB2. But again, we don't know. We are just going to kind of guess here. But a lot of us are hoping that we're going to see a really high movement on the EB2 and EB1. So let's hope it does happen. And we're going to have Sharif talking to us, discussing with me about this at a later stage. So this is going to be the big thing probably in the next coming weeks, maybe tomorrow or the day after, because usually on October 1st is the new fiscal year, right? So we have all those things happening, and also H1B kicking in, etc. So I recommend that people watch on their visa bulletin website and check what is going to be next. So that's kind of a first, at least hopefully some good news coming up. But again, we might be completely wrong. There's no way to tell. But at this point in time, we are hoping that it is going to be some good news coming. So having said that, now a lot of things also bad happening. There are things that are really confusing, especially for those people who don't know if they should go for visa stamping or not, based on the ban, the H1B ban. And that ban is actually kind of basically blocking a lot of people to go for their visa stamping, but there are exceptions that were issued, and of course it seems like anybody who kind of meet the requirements of the exceptions might actually be not having any issue. And so far, except the long line or the issues are not really present. So if you want to go for stamping, you can, but I don't recommend doing it, by the way, although they are opening the doors kind of, and this is maybe because of the elections, or maybe they don't see there's COVID, or I don't know, guess why. At least we know people are still now able to go for stamping, especially those who badly need it. Now the question, can you go in a third party country? That's a big question that a lot of people ask. For example, they ask us, can they go to Canada or to Mexico for H1B stamping? Well, yes, depends on your situation, but unfortunately I know there are a lot of restrictions right now because of COVID for Canada, so they might not be able to get there. And plus, if you're not a resident or a citizen of Canada, they might not even take you for the next 6-8 months. So the best is to go to your home country. If you're from India, just go to India. If you're from Pakistan, go to Pakistan, especially for the H1B. As for the H4, the rules are a little bit less strict, so you can always go to Mexico, for example. But H1B Mexico, most of the time they don't take those cases, so just be careful if you're trying to go to Mexico for stamping. So that's another thing that I get frequently asked as a question. Now, the other thing that we saw yesterday, there will be flexibility applied when it comes to requests for evidence. That's the announcement for the USCIS. I don't have a lot of news on that, except you can request a continuation N14 on notice of intent to deny, intent to revoke, notice of intent to rescind, and notice of intent to terminate, etc., and motions to reopen on N400 cases. So, as you know, most in the past, if you have a request for evidence, you couldn't really request any kind of additional time to answer those, because if you don't answer, you get automatically denied. But with this new ability to request an extension on those RFEs, it kind of helped people. But of course, there's always a risk they don't accept it, so it is important that you try your best to answer on time. And by the way, since I'm talking about request to evidence, for example, it is very important that you give a clear answer, okay? You answer all the points, and points you cannot answer, for example, you make sure that you explain why you cannot answer or you don't have an answer. Don't just leave it blank. It's not an exam that you're going to pass on the other marks, so make sure you address every issue. And a lot of people, they tend to freak out, unfortunately, and they don't really give a good answer. So in these cases, I will recommend hiring an experienced attorney to help you, and we can help you, of course, but at the same time, don't try to kind of rush into a request for evidence just because you want it out, and then you missed on important parts. It is very important, but at the same time also, again, do not wait the last minute, because I've seen cases where the request for evidence reaches there 4 days late. because when you mail the answer, you get 3 additional days. But unfortunately, people wait so much the last minute that it reaches on the 4th day. So that's another thing that is really kind of is very important when you're moving forward with answering a request for evidence, a notice of intent to deny, a notice of intent to rescind, etc. The difference between the RFE and the notice of intent to deny, the RFE is usually just to request information. The notice of intent to deny is already kind of, they're planning to deny your case, so they're just giving you a last chance to explain yourself. So remember, when you're answering a request for evidence, the weight of the answer is always weaker than the one when you have a notice of intent to deny, for example, or to terminate. So make sure when you're answering, you don't answer it the same. You need to basically do not only a factual analysis, but you also have to do a legal analysis. And that's where a lot of people kind of miss it, because they either do all thoughts legal analysis, they forget about the facts, or they put only the facts, they don't mention the law. Because remember, the officer who's sitting there looking at your case, he might not be educated in all the issues of law, so he's just seeing things according to his checklist. And if you basically educate them when you're answering your request for evidence, you might actually win your case. And we have seen that many times, apparently, how it works. And unfortunately, many people tend to just try to template things. That's another problem too, because if you try to template a request for evidence, oftentimes it might not match your answer, because you're just taking a template for a different answer, a different question, and you're just plugging in your facts, and that doesn't work. And this is the biggest issues we see with, unfortunately, many new lawyers, and also people who just wants to, because they tend to follow the trend, right? They saw their friend doing it this way, and they just do it this way. But it doesn't work all the time. Most of the time, it doesn't work. So it is important that you actually kind of take your time to answer those requests for evidence. And even if your lawyer is actually working on this, it's good you review it before they send it, because even as a lawyer, sometimes we might miss some facts. And hopefully we don't miss the law, because that's the important part. But the facts, it's usually your facts. So you might know your facts better. So if you get a chance to see the answer, it's always good before they send the case. So having said that, people have to also know that preparing a case can avoid a request for evidence if at the outset, when you prepare the case, you actually kind of put yourself in the shoes of the adjudicator. So for example, if you're answering something incomplete, or you're presenting something already incomplete, expect that they will want an explanation. So, but at the same time, you should not volunteer information. That's another mistake a lot of people do, because they tend to give too much information or not enough of it. The balance is very important, because
you just need to give the right information, neither too less nor too much.
Exactly. And that's where the balance becomes major, and many people tend to actually kind of oversee things or overdo, and it can backfire on you. That's why we have the rule in law, you have the right to remain silent, and anything you say can be used against you. That applies also when you're answering a request for evidence, or you're preparing your case and submitting it. Because I know many times people will put information that are irrelevant, but actually by putting those information, USCI start digging and say, okay, why did you do this? How come you did that? And this is not legal, etc., etc. And you put yourself into a situation which should not be there. You need to stay to the point, and that's where experience becomes very valuable. And when we do those kind of cases, one of the reasons I'm proud to say that we are able to get such a high number of victory is because we are able to find this balance with experience and having dealt with so many of those difficult issues. So again, if you need help, we are here to help. You can call us 510-742-5887. Do you have any questions around that?
No, I don't have any questions, but in fact, I wanted to remind the listeners that if they have any questions, they can definitely call us right away. 510-657-1170. That's 510-657-1170. Listeners, any questions that you have, any questions about immigration or family laws, especially about immigration, call us right away. We do have a caller. Let's see what they'd like to ask you. Hello, you're on air with Shah.
Yes, can I talk to the Bada Sahab?
Sir, आप बैकग्राउंड में रेडियो बंद कीजिए मोहम्मद जी.
हाँ.
He is listening. Please go ahead. Hello. Mohammed ji, please turn off the radio in the background.
Maybe.
Hello.
Hindi bole?
No.
Hello.
Mohammed ji, yes. What's your question, Mohammed ji? He is listening.
मेरा क्वेश्चन ये कि मैंने वाइफ के लिए 2.5 साल पहले अप्लाई किया था. अच्छा, इंटरव्यू वगैरह सब हो गया है. आई ऑलरेडी सबमिटेड ऑल द रिक्वायर्ड डॉक्यूमेंट्स टू पाकिस्तान एम्बेसी इन अमेरिकन एम्बेसी इन इस्लामाबाद, और दे टोल्ड मी के माय फाइल इज इन administrative processing. So how long it will take?
So Shah,
and when I will get visa?
Right. So Shah, his wife is in Pakistan, and he filed for her 2.5 years ago in the American embassy in Islamabad. Yeah.
और वो administrative processing में file is.
That's what they keep telling her, that the file is in administrative processing, and he has no other update. And he actually has been calling and asking about these to a lot of people, but nobody has the right answer. So what do you think is happening?
Okay, this is a very frequent question, especially for Islamabad, Pakistan, because what happens is that they have something called administrative processing, which is under section of INA 221G. There are 3 kinds of 221G. One is basically just a few evidence you have to provide. There's a second one where they basically kind of are doing a background check, and the third one where they get stuck because we have something which is very discriminatory that happens right now. I think you got stuck because of the Pakistan situation, because there is something called CAARP, CAARP, that was a long time ago was set, right? And under Obama we were able to find this out, that they kind of discriminate with certain people from Southeast Asia, including some parts of India and some parts and many parts of Pakistan, Nepal, etc. So I think at this point we need to know if there are issues in that. One move I would recommend to do: contact your congressman if you're a U.S. citizen. Right now is a good time, elections, and depending where you live, go online, find who's your congressman, and then call them, tell them to see if they can find out exactly what is happening on the case. If you do a background check,
वो कांग्रेसमैन को हमने खन्ना साहब से मुलाकात की थी. तो खन्ना साहब ने भी उनको लेटर भेजा था बड़ा जबरदस्त स्ट्रांगली, मगर वो उन्होंने बोला कि भाई अभी से एम्बेसी बंद है और हमने इनका केस जो है वो एडमिनिस्ट्रेटिव प्रोसेसिंग में डाला हुआ है.
So, Shah, did you understand, or do you want me to repeat that for you?
I kind of understand. Let me just kind of reiterate. So basically, he contacted Rokhana, and he basically told them.
उन लोगों ने email भी भेजा था embassy से.
Right. So Rokhana wrote a letter, but they said that the embassy is closed and this is the administrative processing, and they also sent an email from the embassy.
Yeah, and I got email from them that everything is okay. And we don't need anything. If we need anything, then we will call you.
Yeah.
उसको भी 6 महीने हो गए.
Yes. So there's nothing we can do because of the embassy part. But unfortunately, if it is under the background check, nobody can really do anything. The only way you can unclog that, and it won't work right now because the embassy is closed, is to sue the government.
Embassy is closed, the flights are not operating.
जी. So let him finish एक बारी. मोहम्मद जी सुनते हैं what he wants to say. Let's see.
So basically, if it is embassy is closed, there's no real solution. There was a solution which is suing the government, but the suing the government is very costly because you have to do what we call a writ of mandamus in federal court, and not many lawyers do that. I used to do a lot of them, but right now I'm not taking them because it has a lot of risk in it. Because once you file that, they start digging in your case, and any small mistake they can use it against you. So I would recommend just be a little bit patient. Inshallah, you should be cleared, and then we'll see how things work out. And if they still don't get anything within like after the embassy is open, give me a call and we'll see if we can handle the case for you.
Thank you so much, sir. I'm really appreciate. And
no problem.
We are helping the people. God bless you. God bless you. Thank you, Hiraji. Thank you very much.
Thank you, Mohammadji. Thank you very much for calling in. Listeners, if you also have any questions, kindly call us right away on 510-657-1170. That's 510-657-1170. Yes, Shah. Let's continue. Meanwhile, we'll also have Sharif on the line.
Okay, perfect. So, as I was mentioning, this is a very good question, Muhammad Az, and this is happening a lot. Especially we had cases from Hyderabad and Punjab getting stuck a lot because of this carp thing. Carp sounds like a fish, but this thing is a very unfair rule because they have been openly discriminating against people of certain region of India, Pakistan, Nepal, Bangladesh, and some of the other surroundings. And we, under Obama, we were able to clear a lot of them, but ultimately when Trump took power, it became like a norm, almost like, unfortunately, openly done. So let's hope things will get better. We don't know how the elections are going to work out, but let's see. And plus now with the COVID, the embassy closed, things are not going to be easy for anybody. And next year is going to be harder, so be ready for that. Having said that, there are ways we can work out things, and if we can, we'll be glad to help you. You can just give us a call, 510-742-5887. Ira, is Sharif there? No,
not yet. I'm trying to get him.
Okay, great. So let me continue just before we have Sharif on board. Sharif is the attorney in our Washington DC office. He's a managing attorney there, and he handles mostly EB1 cases, national interest waiver, and also E2 visas for investors. For example, if you're from certain countries which are under the treaty visa, you can go for that. And also he handles all the L1A cases and things like that. So today, hopefully, I'll have him, and we'll discuss mostly today about the effect of the visa bulletin, how things are going to work out. I have a feeling we're going to see a movement on EB2, but unfortunately, I think Sharif has a different view on that, and I think he's thinking more on EB1, there will be movement, and EB2 will be stuck. So we will figure out what is his views on that, but I was talking about that. Yeah, the visa bulletin is big. So I think Sharif, assalamu alaikum, are you there?
Walaikum salam. How are you doing, sir? How's everything?
I'm doing well. So Sharif, tell us a little bit what's going on the EB1. Congratulations first for the win of those two big cases that you won in a row. Tell us a little bit about them, and then tell us what you think what's going on right now.
Yeah, just in the past 3 days, we've had 2 approvals issued without RFP. I think it's very, very clear that we have the right formula for getting approval, and we know exactly how to get the approval. I think the most important thing for folks out there to understand is that most of the information in the forums, most of the information that's online is not necessarily accurate for your specific situation. So there may be accurate information that exists online and in forums, but it does not necessarily mean that it is accurate as it relates to your specific situation. Every single case is different, and every single case needs a uniquely tailored approach in order for it to be approved. So there's really no shortcuts in this. I think that oftentimes the people who are patient, who are compliant with the instructions and recommendations that I give from the professional standpoint, we give as a professional in this legal field, those are the successful ones, and those are the people that are doing very, very well. So it's not always the fastest process in relation to for example, other kinds of areas of immigration law. So if somebody's, for example, presenting an H-1B, you might be able to do it in very, very quickly because there's so many timing sensitivities and things like that. But with respect to a self-petition, either an EB-1A or a national interest waiver, it needs to, you need to make the good food always takes a lot of, effort and time and energy. I think if, anybody does any cooking at home, you'll know that, if you try to do the fast food and just put it in the microwave, it's not going to taste the same as, the slowly cooked, low temperature and perfectly executed meals. So, that's basically what we're doing is we're doing perfectly executed petitions. And it takes a level of intelligence and ability that, not everybody can necessarily process.
Exactly, and I was always telling people you might have the ingredients, but if you don't have the cook, it works, but it doesn't really work well. Although in other areas, like you say, sometimes it's very easy just to fill the forms and submit it. When it comes to EB1, it requires a lot of almost like an artistic kind of talent to do it. And personally, I take a different approach, and you take a different approach, and your approach is working. So, hats off to you. And Sharif, tell us a little bit about. We were talking about the visa built-in earlier. So, tell us, what is your take? What is going to come?
This might be the most significant visa bulletin in the last several years that is coming up here in. It could be this week, it could be next week that it's released. Because of the COVID situation, there has been a huge reduction in executive orders and other reasons, a huge decrease in the number of visas issued abroad. Therefore, there are about 100,000 family-based visas that are going to be moved over to the EB category. And I think that the result of this is going to be such that we're going to see, probably EB1 will be current for all countries as soon as, October. So those of you, I know many of my clients who already have approval are waiting for that one, so there's a lot of people who have approval and we already got their green cards because they had a previous EB2 and we ported that EB2 date to EB1. So we have many, hundreds in those. But also there are many who are individuals who do not have a previously approved I-140 and we got their EB1A approved, but their priority date is, for example, 2020 or 2019. And they are, waiting for that October 2020 bulletin to be released because, hopefully those will be current for all countries, including India, China. So that is what we're waiting on. I mean, I know it's kind of a bold prediction, and, so you probably have your predictions as well. But, so I don't know. Maybe I'll look bad in the end. No. But I think
I kind of came up to the same conclusion as you, plus also seeing the delay in the... Usually when you see a delay in the visa built-in, there are three reasons, of course. There's number one, new fiscal year, which is still not that bad. But the second one is either a huge retrogression or a huge jump. And based on the data and the reasons you gave, I thought of the same thing. I didn't think about the part of those people not able to apply from abroad. But yeah, that's going to have an impact definitely on the number of applications. So for all of you guys who have your stuff ready, so get them ready to file your I-45 hopefully. And we will be helping a lot of people. I already started getting emails. People are getting ready. And I think that feeling is already shared by a lot of people from India contacting us, especially who have been waiting desperately for years. Hopefully things are going to get better for them this year. But having said that, we don't know how EB2 is going to behave. EB2 has its own kind of caprices, and I don't know how to put it, but hopefully we'll see also a movement on EB2. But but it won't be that great of a movement, of course, like EB1 and EB3 also. Now the question is that how EB3 will move, but a lot of people jump on EB3 for India because they saw EB3 moving forward. But that might not be the case later, because the problem is that when people start jumping on something, after a while you're going to see a backlog in that category. So I think the EB1 is still the best choice, because we saw a lot of people. And by the way, you were mentioning people who have a previous I-140 approved. We can port the dates. I repeat that. We can port the previous dates. But also one thing a lot of people ignore, if your spouse is born in another country, you can basically do what we call cross-chargeability. So you can use their country of birth to bring the case current. So remember that. A lot of people don't know that. So look into that, because I just spoke to a client this morning who was waiting, and then he just got married, and he wants to know how he gets an H4 and et cetera, et cetera. And then I realized, hey, hold on a second, your wife is born in this other country, so we can just directly file the adjustment of status, and all of you guys got their EAD, and you don't have to worry about all this. So a lot of things is happening. So what's going on the national interest waiver, Sharif? Because a lot of people have been calling us to do national interest waivers. How are things going there?
I think the national interest waivers are, definitely going well. It's interesting because you read and you see so much about the negative sides of the immigration situation, and, obviously even on Twitter and elsewhere, there's so many attorneys who, have horror stories. Frankly, I'm just not seeing it in my own, experience. In our practice, we've seen, really successful outcomes for national interest waiver, for EB1A. I mean, sure, you can kind of see a rise in RFE requests for maybe some of the more simple, for I-485 adjustment of status, we see some silly RFEs. They're requesting stupid stuff, but you can satisfy that pretty easily. But overall, I would say that the high-skilled areas of immigration law have not been heavily impacted as, some family-based categories or, asylum or humanitarian-based categories. The high-skilled employment situation, if crafted in such a way, I think one thing I would say is that folks tend to craft their petitions according to why they themselves need the immigration benefit. We craft our petition according to why the United States needs this individual to remain here. And that is a huge difference. Because if you're making the argument that, hey, dear government, I need this, I need this, I need this, I need this because I will do this, that is a lot different than making an argument of, dear immigration officer, this is my skill, my talent, my experience, my ability, this is my track record, this is how I compare with other individuals in my field, and I am prepared, ready, and able to execute on behalf of the United States to advance the U.S. economic interest, to advance technological ability, to advance whatever area, academic area, etc. That is you're presenting things in a much, much different way. I mean, there is a real, like you mentioned, there's an art to this. And I would say that it is an art of persuasion, but it's also an art of influence. You see, influence is something that is really, really important, and people don't necessarily realize the power of influence. And words can influence. It could be very subtle how one articulates a particular point of view or articulates, shares the, let me just kind of make this into an example, I think, to illustrate it for you. So some people maybe have worked at a particular organization. All right, let's call it, a bank. Okay, they work as, in a finance, data analysis role at a particular bank, and they've done so for 3 or 4 years. So if you've done that for 3 or 4 years, and the only evidence regarding that 4 years of work is a letter that you're getting from some manager or some person, and you think that that is going to influence the officer to do something, you are not thinking properly. I'm sorry to tell you. One damn letter for 4 years of blood, sweat, and tears. Every day you went there, every day you contributed, every day you did things. Are you really, really thinking clearly about articulating a very, very powerfully presented and influential petition regarding the work that you completed for that 4 years at that bank with one letter of 2 pages that is just talking about nonsense and lofty language and about how extraordinary or how great you are? That's not the way you get an approval. So I think that a lot of times, people are dissuaded from pursuing either an EB-1A or a national interest waiver based on someone they know who tried it and failed or something like that. But again, if you take a uniquely tailored approach to your case, it really doesn't matter what happened with somebody else in a negative way. What matters is you have the correct advice, you have the correct approach, that you are being persuasive, and that you are influencing the adjudicating officer in such a way that will result in an approval. That is what this process is all about.
Exactly, and Sharif, this is one of the things that I always get. A lot of times I see people calling me and say, okay, how come we are able to do that when others are saying no? We are not doing miracles here. All we are doing is basically showing things in a different light. And without having to change things, only thing is just how you present it. It's just like when you are selling something, if you package it nicely, you're selling the same product, you might be able to sell it for more expensive for the same product, and then you would have sold it on just putting it in newspapers, right? So use newspapers, right?
That's exactly right.
That's where a lot of people get confused. And I had other lawyers calling me, say, how come I did the same thing, it didn't work? Well, it didn't work because you didn't present it properly. So you expect the person who's spending like 15 minutes on something to basically go and do their own research to approve you. It's not going to work. And that's why I always tell people it's not just a factual analysis, it's a legal analysis. And this is where you have to be able to use both and be able to basically juggle with both and make it happen. Because if you use only one part, you use only the factual part, it's not going to work. You use only the legal part, it's not going to work. In fact, even you use both, it might not work unless you are able to really find that magical thing that is inside of it and just bring it to light. And you're right on that, and I see that. I've been seeing this. I've been doing this now for 15 years, and I see the same mistakes. And I used to teach lawyers, and they will argue with me, okay, I put the same thing you just told me, and then when I look at what they put, they expect the officer to find something as evidence and basically understand what this evidence means just because they put it out there. Okay, you don't explain what it is, why you put it there, and that's where the biggest mistake is. And that's what we have been kind of developing over the years, that we not only take the evidence, we're able to explain why this evidence is relevant and why is it important. And just like JFK said, it's not what your country can do for you, it's what you can do for your country. And that's where the secret is, and it's not a secret, in fact. We're telling it to everybody. But now the question how to present it, this is where the talent comes into play. And hats off on that, basically, on putting this together. And Sharif, the National Interest Waiver...
Speaking of talent, really sorry to interrupt you, but speaking of talent,
go ahead.
You reminded me of the olden days when I used to be in college. I used to work in the mall at a cell phone booth. And we would sell the cell phone products to clients, to customers, And, if the people who were talented, who knew how to present the facts regarding the service, would sell, maybe 100 phones a month. Other people would sell 15 phones a month. Other people would sell 10 phones a month. I mean, talent matters. The ability of the advocate is going to make a huge difference regarding whether or not you will be approved for your petition.
Yes, exactly. You're right. And I was a car salesman in law school, so I know how it works. The truth is that many times people will come to you and you're honest with them and you tell them the truth, and at the same time you show them things that they can really afford and you can understand what they're going through, etc. People will come just to buy a car from you, not because of the price or the car. It's just they're coming because they like you, and that's why they say salesmen sell themselves. But in this case, what we're selling you, not in a bad way, but in a good way. So people should understand that in order for you to be able to do that, is you have to have value, and the value is not what you think your value. You're saying, I am this and that. It's what I am for you. That's the whole difference, right? And that's where we're seeing a lot of cases failing and succeeding. And of course, we can go on, basically, and that's where that's what we can say makes the difference. But Sharif, just because we are talking about national trust waiver, one of the things that people tend to do is they just look at those checklists. And the truth is that it's not a checklist, right? I keep saying that because people have to understand what we're doing here. Tell us a little bit about what they're looking for and the two cases which are the main cases, because there's no real statutory law on that. It's mostly a case law, right?
Yes. Yeah, I would even just, rely solely on what's called DANASAR, DHANASAR. So DANASAR is the most recent and binding case that determines qualification for the national interest waiver. And under DANASAR, so you need to first, before you even get into the details, you need to understand that for a national interest waiver, you need to at least have a master's degree level education. Now, if you do not have a master's degree level education, you can still qualify for a national interest waiver, but you need to prove what's called the E21 extraordinary ability. One such requirement for that extraordinary ability under E21 for the national interest waiver is to have a bachelor's degree. Another is to have 10 years of work experience. And then you need to meet one additional criteria. It could be, for example, that you have high salary, that you have reviewed and judged other people's work, that you have a publication, any of, a number of criteria. So I think even if you do not have a master's degree, if you're in the conversation for a national interest waiver, we will be able to help you regardless. Now, once you've established either a master's degree or that you have the E21 extraordinary ability and can proceed to the actual analysis, the point of the national interest waiver is first and foremost not necessarily about your own profile. It is about the area of work that you're involved in. So what the actual legal analysis requires is that you are working in an area of national importance and substantial merit. So you work in an area that requires one to have a great level of skill and ability, and one that qualifies as being of national importance. Those are the two requirements for the national interest. Those are the first requirements for the national interest waiver. That you work in an area that is of national importance and that you have that it requires substantial merit. So just a couple quick examples. I think that a lot of times we are quick to go into postdoctoral fields. That is not at all what is required for national interest waiver. And even for EB1A, you don't need to be postdoctoral. But if you are a postdoctoral individual, more power to you. We could definitely help you. And it's, we've done many, many cases such as those. Now, what we are looking for in terms of national importance is something that benefits a sector of society, the economy, or national interest. So, for example, one such, actually, I would say a group of cases that we have done has been, and it could be very wide variety. So, for example, people that work with autistic children, right? They provide some kind of support, mental health, whatever, different education strategy for children with autism. That is an area of national importance. That is something that requires substantial merit. Now, you could look at a completely different spectrum. For example, we've done a lot of national interest waiver cases for people in the oil and gas industry, petroleum engineers, certainly materials engineers, civil engineers, anybody that's basically in engineering is going to be there. Software engineer and data analytics experts, so like data scientists, certainly are in areas of national importance that require substantial merit. So the first part of the analysis is really about the area of endeavor that you're involved in, the area of work that you are in. Okay? Now, the second area, the second thing that you need to understand about a national interest waiver is you need to demonstrate that you are well positioned to advance the area that we have identified. So we identify an area that is of importance and, requires merit in order to be undertaken. And secondly, we look at whether you are well positioned to advance that area, or we demonstrate to the officer that you are well positioned to advance that area. And I would argue that one of the best ways to show that you are well positioned to advance the area is through credibility evidence. That is to show that you are highly credible through other credible people. So when I say credibility evidence, I mean someone who is themselves credible and is extending their credibility to you. Now, there's two things that you need to understand about credibility. Number one is the individual who is credible should be at some, maybe it doesn't have to be a C-suite level, but they should have some directorship or maybe a VP, or if you're talking about the corporate world, if you're talking about academic world, they could be a professor or, researcher, for example, who has some accomplishments, but they themselves need to be credible, all right? Now, the other point about credibility is that they should not have any direct connection with you. So for someone to be credible, they need to actually have some arm's length relationship with you. That if you have there's no overlap in your resume or CV, they work in a different area than you. That is what credibility is about. That way they provide kind of a perspective that is, testimonial, meaning that they are giving a statement to a government officer that is under the penalty of perjury and are doing so in such a way that is really very believable. And that is what credibility is all about. So that is just one example of the kind of evidence that you need in order to accomplish a national interest waiver. There's other examples. Another take I have is what's called reputation evidence. So, I don't know if we have time to dig into that, but certainly, there's approaches, in every case is different.
We have another 5 minutes, Sharif, so...
That's right. We do have about 5 more minutes, and I'd also like to remind our listeners that if you have any questions, we have 5 more minutes to go. This is the time if you want to call into the studio number, 510-657-1170. That's 510-657-1170. Listeners, also, if you would like to get in touch with Shah or Sharif, Attorney Shah or Attorney Sharif after the show, you could do so by calling their office number 510-742-5887. 510-742-5887. Now we have 4 minutes.
Yes. Go ahead, Sharif. Tell us quickly, and then let's talk a little bit about EB1 before we finish, because that's another major thing, because EB1 doesn't even require you to have a degree, actually.
Exactly.
You might even qualify
let me do that, because I think this applies to both EB1 and national interest waiver. So just for this week, right, I'm not going to reveal any confidential information, but I do want to mention one thing that I think is very, very important. That is the approvals that we are getting, right? They are, like, for example, I had one individual who has a PhD, right? Now, the problem or the point I want to make is that having a PhD is not what caused this person to be approved. It had nothing to do with the PhD. Actually, what it is about is how you are positioning yourself in terms of the overall field that you are claiming to be an expert in. So if, for example, you have a PhD, but you don't have citations that are off the chart, that doesn't matter as long as you are not submitting your case as an extraordinary academic. You know, you can be a PhD, for example, and let's say your area of expertise is in, I'm just going to take something silly, like folk dancing, okay? So your area of expertise is folk dancing. As long as you're not going to say that I'm an author and a PhD who's only going to deal with the academic teaching and research of folk dancing, then it doesn't really matter that you have less citations than other people. But if you say, you know what, I'm a PhD in folk dancing and I'm now opening a folk dancing company where we're going to do shows all across the country and we're going to bring the greatest and best folk dancing art to, places all over the United States, and everybody's going to have a great time, and we've already started to do this. See, now you're not using an academic argument in a postdoctoral context. You are using a very practical approach. So you may have a PhD, you may have publications, you may have some citations, but what you are doing is you are performing within industry. You're not performing within academia. This will give you a much better chance at approval than going through the academic realm. Because if you are in the academic realm, then there's a simple question that we have to ask. Why are you applying under EB1A? Why are you not applying under EB1B, which is for outstanding professor and researcher? If you are an outstanding academic, you should be applying under EB1B, not under EB1A.
And I remember, I think when we were talking about the O visa, I remember Attorney Sharif had said that you may not think that, you are extremely special, but we are extremely special for proving that you're extremely special. So, there we go. Thank you so much, gentlemen. We are at the end of the show here today, but thank you very much for being here and for this great information. Listeners, once again, let me quickly remind you appointment, or if you need to speak to them over the phone, you could do so by calling up 510-742-5887. That's their office number, and the website is peerallylaw.com. That's PEERALLYLAW.com. peerallylaw.com. They will be back with us next week, next Wednesday, 10 a.m. to 11 a.m. Pacific. Thank you once again for being here. Stay safe.
Thank you, Sharif. Thank you, Ara. Take care. Bye-bye.
You too, and thank you, listeners, for tuning in. Stay tuned to Radio Zindagi. Ji jao.